Welcome, everyone. Thanks for being here today. Today, I'm visiting with Ralph Munyan, a Prairie Village attorney. Welcome, Ralph.
Tim, it's great to be here. Thanks for having me on.
You bet. Hey, could you share a little bit about your background, please, with us?
You bet. I'm a business attorney. I've been practicing for about 23 years. And my practice areas basically are in the areas of three areas. Mergers and acquisitions. So if you want to sell a business or buy a business, I'm your guy. Also, I do a lot of contract work, especially in the technology area. I was general counsel for quite a while for a technology company, which gave me great experience. And plus, I love technology. It's just fun.
That's great.
And then human resources, which is a lot of, I think, what we'll talk about today. So those are the things. Tim, if you don't mind, I sort of need to give a disclaimer.
Absolutely, please.
It's a typical lawyer disclaimer. Basically, the information I'm going to give today is informational only. It's not legal advice, and it does not create an attorney-client privilege or attorney-client relationship. Sorry.
Good deal. Good deal. Thank you for that. I appreciate that very much.
Thank you.
Yeah, absolutely. Hey, so Ralph, I'm curious. I've been visiting with a lot of folks about COVID-19, and it's had a pretty wide impact on a lot of industries.
Yeah.
I'm curious as to what you're seeing with your clients in terms of its impact from a legal standpoint.
Sure. Well, as you know, Tim, lawyers deal with business risk, and their job is to reduce business risk as much as possible, especially contract type lawyers like me. Litigators will deal with the facts after the milk's been spilled. And I try to deal with them up front so the milk doesn't get spilled, or if it gets spilled, it's spilled in my client's favor,
Good.
So what I'm seeing with COVID-19 are a number of different liabilities. They're always out there, but they've been heightened really by COVID-19. The first is premises liability. A lot of the issues revolve around your business putting what they call invitees, your customers and your vendors, and also your employees, although technically they're not invitees, but those people at risk. And if on premises liability, if somebody comes on your premises and let's say you hadn't done anything really to clean the place up or anything or very little, and somebody got COVID-19 because of it, or if an employee had COVID-19 and you let him go just the day before or something, but didn't advise people of that there's just by coming on your premises, you have premises liability risk enhanced by the COVID-19. Another big one is
Ralph, can I ask a question there? So does this liability deal with both employees and folks who come on premise? So visitors and employees?
I think the short answer is yes, absolutely. I didn't include employees in that list because employees obviously are there all the time, and there's a lot more issues or different kinds of issues where employees are involved. And I'm going to talk about those in just a few minutes, but they're going to involve human resources issues.
Good, great.
Yeah.
Okay.
So the next thing I'll talk about is negligence-based claims. I mean, negligence is basically where you did something or failed to do something that was either reasonable to have done or reasonable to not have done. And so negligence-based claims could be kind of that same as the premises. You didn't protect a visitor from the risk of the virus, risk of exposure, when that harm was reasonably foreseeable. As I think, generally speaking, you could certainly make a case that it's reasonably foreseeable at this point. The second would be if you negligently hired someone who you didn't screen properly for their health history within the guidelines. I mean, you can't ask about things, but if you know they were sick, if you took their temperature, which you're allowed to do now, it's an exception to the American with Disabilities Act. You're allowed to take their temperature or to ask about their temperature or their medical background. So if you hire someone that was sick or recently sick and one of your visitors came on premises or just was interacting with the employee, even say their office, and they got sick, then they could sue you for negligent hiring. The third negligence issue that I'd like to talk about is basically claims of negligent infliction of emotional distress. That can be where somebody comes to Susie's, boutique or whatever it might be, and the next day we learn that an employee went home from Susie's boutique just after that person left and probably died of COVID-19. I mean, that's not a good situation, but somebody who just been in there could go, I feel scared to death that I'm going to get the same person's thing. And that would be an example of negligent infliction of emotional distress. Again, it goes back to improper paying attention to the details. You're not screening your employees. You're not keeping your workplace clean. It can even come down to just signs. You can even have signs up that weren't up, maybe.
So it seems to me, Ralph, and I'm not an attorney.
Sure.
This is out of my area of expertise, obviously way out of it. But it seems to me that you are talking about HR sort of policies, not contractual sort of issues, but really HR things, sort of policies and procedures that businesses should implement to make sure that they're staying abreast of the COVID issue. Is that right?
Well, a lot of them are HR issues, but there are other things as well.
Okay.
There are contractual issues, and two that come to mind are indemnification clauses and insurance to cover those. An indemnification clause says that if the person, if I have a contract that says I'm going to do X, Y, or Z for a person, but if something goes wrong, they're going to indemnify me for the damages. Or on the other hand, if I say I'll indemnify you when I come in and move in your new piano, and I'll indemnify you not to drop it through the floor, but it drops through the floor and it costs you $10,000. And so I've agreed to indemnify you for $10,000 for whatever it costs to fix that damage. It's very important that people review their contracts to look at their indemnification promises, really. And if they have, and the $10,000 is a really small example, but most indemnification clauses you'll have like $1 million of insurance or $1 million of exposure, whatever it might be. So if you do have $1 million of exposure, make sure your insurance covers you for $1 million. The other thing too, and I learned this from a local insurance guy who's really great, Travis Holt. I don't know if you know him, but he does a lot of technology insurance, excuse me. If other people have promised to indemnify you for $1 million, you should do, it's recommended, if possible, do an indemnification audit or insurance audit.
Right.
Do they have the wherewithal financially or the insurance in place to actually make good on their promises? So instead of dropping the piano through the floor, they blew up the entire building. Do they have the wherewithal to make you whole? So that's always a good idea too. The other thing I'll talk about is we don't see this a lot with smaller businesses, but you can have a force majeure clause. Are you familiar with those, Tim?
No, I'm not.
Well, a force majeure clause is the typical act of God clause.
Oh yeah, sure.
And it says that if something, because a contract can't cover every single risk out there, that if certain things happen, act of God is the most famous, but it could be a flood, a hurricane, a riot, a strike, a government action, or a virus. If those things happen, that you have the opportunity to either not perform under a contract, perform partially, or not perform for a certain amount of time, for example. The issue is that I said virus, but many of them don't contain virus clauses that say that you don't have to perform if a virus knocks your workplace down. So it's very important you should check. And if you don't have that kind of clause, well, you do have other remedies under common law, but the best reason for checking is that there are certain timelines typically. So if you know that there's a hurricane coming, or say the COVID is here, right? And you have 30 days or 60 days or 7 days to notify the other party that you aren't going to be able to perform, you need to honor that deadline. And so that's another contract issue. Honor the deadline so you can get those, so you can get that protection and be excused from breach of contract. If again, COVID's been around for at least 90, probably 120 days now. If you don't have a force majeure clause, there are going to still be common law remedies that you can invoke. There's no promises, right? No guarantees, but you'll have some defenses.
Well, this is fascinating. I can see why people come to you for advice, because this gets, for a layperson like myself, this gets pretty technical pretty quickly.
Well, I hope I'm explaining it in a way that's not too lawyerly or.
No, absolutely, it makes sense. But I can just see how it's easy to have issues out there that would never come to my mind.
Yeah.
You know, I'm a solopreneur. I would never think of many of these issues.
Right.
So Ralph, as we kind of wrap up here, are there any kind of last words of advice that you would give to folks? Specific things they may pay attention to that, again, may be very easy to overlook.
Well, I'm gonna go back to the HR issues.
Okay.
I call them basically the big 5 HR issues, and they're totally applicable here, especially the first 3, which is really every employer needs to put in written policies about how they're dealing with COVID-19. Typically, they would go in the employee handbook, but they don't have to. But they'd be written policies that say how we're going to deal with it. You know, how are we going to clean the place? How are we going to protect our customers? All those types of things. At the very least, it shows that you're paying attention and you're not just going, oh, well, we'll just act like nothing's happened. So get those written policies, put them in place. The second thing is make sure you enforce those policies. You know, you basically, if you say you're going to clean the faucets once a day, clean the faucets once a day. Because if you don't, then you're violating your own policy. And don't put something in place that you know you can't do. So make it reasonable, but at least you're paying attention and your policy shows it. And also enforce it fairly. I mean, you can't take one person's temperature at work and then not take somebody else's temperature, because that could be seen as discrimination, right? So definitely don't do that. And on that case, I thought it was very interesting. There's a lot of literature that talks about having or taking your employee's temperature at work. But the best thing I read was don't do that. Have your employees take their temperature at home and tell you if they're sick or not. And if they are sick, don't have them come in. And that avoids a whole host of privacy, possibly HIPAA, record keeping, all those things. So tell them to take their temperature at home. So then the other thing, so those 3 things: have a policy, follow it, and enforce it fairly. The 4th thing is, if you do have an episode, if somebody has COVID or whatever it might be, document it in detail. And I do it myself. Send yourself an email. It's got a timestamp. It's got everything on it. It's in as much detail as possible. So if you are sued and 120 or 6 months later, you get sick, you get sued, you've got the documentation right then and there. And then also, once you do all that, just make sure that you document any kind of responses you did that may have come up after that. You know, we retrained our employees, or whatever it might be, or you know, what exactly did you tell that employee to do? Did you say go home right away? What did you do? And just be fair, be aware, and just document.
Fantastic. Hey, Ralph, thank you so much for taking time today and sharing some of your expertise with us about this issue.
My pleasure, Tim. Thank you for having me. I appreciate it.